guys, it's Kathy. I hope you're doing well. We made it to Wednesday night. What a crazy time to be walking around and awake. Crazy. It's crazy. If we're awake at 8 p.m., we should be eating something. I'm just thinking. So I got a guy. The doctor says he's faking it. Doctor says he's competent. But there's still going to be a fight over it. There he is. Now, we've seen this judge recently, not take any BS at all. So, I wonder what he's going to do this time. And don't worry, I'll get the chats up. Here we go. Let's go.
Here.
Oh, yeah. Okay. Good morning, Mr. Wasser.
Good morning.
Can you, state your appearance, please, Attorney Rubin.
Jaden Wasser appears via video conferencing by Attorney Joey Rubin, who appears in person.
So, Mr. Wasser, can you see and hear your lawyer, Attorney Rubin?
Yeah.
And then Attorney Granberg, you're going to appear on behalf of the state?
That is correct, Your Honor.
Mr. Wasser, can you see and hear Assistant District Attorney Granberg?
Yeah.
Okay. I think we're sight and sound sufficient. What do you think there, Attorney Rubin?
I agree, Judge.
All right. So any change to, so we're sight and sound sufficient, any change to the examiner here, psychologist, opining that Mr. Wasser is competent, and then Mr. Wasser challenging that. Is any updates?
No, Judge.
Okay, so you want, we should hear from the examiner. Isn't that true, Attorney Rubin?
Yes, Judge.
Attorney Granberg, are you going to have the doctor? Good morning, doctor.
Good morning.
Are you going to have her testify, Attorney Granberg?
Yes, Judge.
All right, Madam Clerk, swear the witness, please. Thank you.
Do you solemnly swear the testimony you're about to give in this matter should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, thank you, doctor. And Mr. Wasser, just to start things out here, just make sure, can you see and hear the doctor?
Yes.
Oh, okay. I think we're still sight and sound sufficient. Then your questions, please, Attorney Granberg.
Could you please state your name and spell it for the record?
Yes, my name is Jenna Krickeberg. Jenna is spelled Jenna. Last name Krickeberg, Krickeberg.
And how are you currently employed?
I am a licensed psychologist. I'm employed full-time and primarily at Mendota Mental Health Institute. I also have a private practice in which I'm contracted with the Wisconsin Forensic Unit to conduct outpatient competency evaluations.
Can you describe a bit of your educational background which qualifies you to hold those positions?
New business idea, guys. Hear me out. This one's actually really good. Okay, all of these courts all over the country need these type of psychiatrists to do mental evals. And you know how long it takes to get a psychiatrist in there. It takes months sometimes. So we start a business, okay, where we hire these psychiatrists to go into the hospitals and do the mental health evaluations. But here's a perk. There's a perk to our business. We get free access to the psychiatrists because they're on our payroll. So we can just schedule our own appointments for free. Is that embezzling from your own company if you do that? Because people who own a restaurant eat their own food for free, right? So we can do this, right? This is win, 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 guys. We just all need to put money in, buy this business. Someone else has to spearhead it. I don't want to. And then we all get free mental health care forever.
Yes, I first earned my Bachelor of Arts in Psychology from the University of Wisconsin-Madison in 2014. I went on to earn my Master of Arts in Clinical Psychology from Pacific University in 2018. And I earned my doctorate in clinical psychology also from Pacific University in 2021. As part of my training and experience, I participated and completed a predoctoral psychology internship at Mendota Mental Health Institute, specializing in competency treatment and evaluation, as well as a postdoctoral fellowship at Mendota Mental Health Institute in the same.
Thank you for that. Did you evaluate an individual
named Jaden Wasser as it relates to the present case?
Yes.
Kelly, thank
When
you
was
for
that
the gift.
evaluation?
Thank you. Thank you.
The date of the report was March 26th, 2026, but I actually met with Mr. Wasser for his interview on March 12th, 2026.
And after you met with Mr. Wasser on March 12th of 2026, you stated you created a report.
Yes, I did.
Judge, permission to screen share?
We will hire Dr. Orr.
Yeah, that permission's granted. You need to be made a co-host.
I don't think so.
Okay.
Doctor, are you able to see
Finally, Carrie.
a report on your
Kelly,
screen?
Finally.
I am, yes.
Doctor, are you still able to see the document on your screen?
Yes.
And for the court record, this was filed in the court record and it is document 46. Does that appear to be the evaluation that you completed after speaking with Mr. Wasser?
Yes, it does.
We would move to admit document 46.
No objection.
Okay, it's yeah, I'm going to take notice of it. I have it too. So, okay. Court taking notice of that. Unless you want it formally admitted, Attorney Grammer?
As long as the judge is using, or the court is using it to consider the hearing, then I don't need anything
I'll
else.
consider it by way of notice. Next question.
Can you explain the evaluation that you had with Mr. Wasser on March 12th?
Tell you what, Eileen, he can be in charge. We'll send you all the money and you spearhead this. And I love it. Thank you, another Smith. Thank you. Guys, we're about to be business owners. Just send a whole bunch of money to Eileen. It doesn't matter how much. Just send her money. Just send her your credit cards.
Yes, as part of this competency interview, as I do with all competency evaluees, I first review the purpose of our meeting as well as the potential outcomes of the evaluation. We review the defendant's case, including their charges and the allegations against them and the penalties they may face if convicted. We also review the plea options and concepts such as trial and plea bargaining. We review the roles of the court personnel. And I also ask the defendants to apply some of this legal knowledge to their own case by asking which plea they're considering entering, whether or not they'd like to take the case to trial or possibly consider a plea bargain. I asked Mr. Wasser of the same questions. Notably, he did seem quite dismissive of educational tutorials that were offered to him throughout our meeting. He dismissed his legal knowledge or attempted to minimize it, offering many I don't know responses while also highlighting his poor comprehension and confusion of court-related matters. As such, the interview was quite brief. It was only 40 minutes. Nonetheless, he did demonstrate that he had some intact factual legal knowledge during the course of the interview. In coming to my conclusions regarding Mr. Wasser, I took a big picture perspective of his performance in prior competency evaluations, as well as his participation in the outpatient competency remediation program. Although Mr. Wasser exhibited some deficits during our meeting, again claiming to not know information, this was inconsistent across evaluation points. For example, with me, he dismissed knowledge or claimed ignorance of topics that he has previously demonstrated knowledge of, and he generally appeared to continually put forth poor effort across evaluation points and in his restoration.
No, it's not a bond hearing. So, all right, this guy has committed a long history of crimes, and a lot of his cases have been thrown out because they say he's mentally incompetent. So he committed another crime, and they sent him to this doctor to get a competency evaluation, and she said, yeah, he's competent. He is competent. And the defense, his attorney saying, no, you got to dismiss the case. He's really not competent. So we need a hearing.
As I note in my report, Mr. Wasser has previously been found competent to proceed as recently as February of 2025. At that time of
So again, with his history, sometimes he's found competent and sometimes he's not.
that evaluation, he did not exhibit any major cognitive deficits. He was able to demonstrate intact knowledge regarding his case in the court proceedings, and he was able to learn and retain information offered to him. I therefore utilize this information to come to...
Doctor, you just discovered a whole new mental health issue. Maybe you could write a paper on it and get famous, called selective competency issue.
my opinion, that Mr. Wasser does not lack substantial mental capacity and that he can assist in his defense.
And do you come to that conclusion within a reasonable degree of certainty?
Yes, I did.
Do you have any reason to believe today that your finding that he does not lack the capacity has changed?
No.
Nothing else.
Attorney Rubin.
Thank you, Judge, and good morning, Doctor.
Good morning.
I wanted to first, I'm looking through the your report. You noted that Mr. Wasser, this is at the bottom of page 2, but you noted that Mr. Wasser appeared to be a reliable source of information regarding his relevant history. Is that right?
Yes.
And do you believe that the reported prior mental health diagnoses, which Mr. Wasser reported to you of ADHD, a learning disorder, and oppositional defiant disorder, are accurate?
I believe they could be accurate. Yes. I did not have any data to corroborate that, for example, with educational records, but I believe that could be accurate.
And in addition to Mr. Wasser's the finding of that he's competent in February of last year, has Mr. Wasser also been found incompetent in past cases?
Yes, he has.
And you put in your report that Mr. Wasser, you diagnosed him with unspecified neurodevelopmental disorder. What is that, or what are the symptoms of that disorder?
Yes, this is a diagnosis that's offered when I'm unable to provide a more specific diagnosis within that neurodevelopmental spectrum. So both of Mr. Wasser's reported diagnoses of a learning disability and ADHD would fall under that neurodevelopmental umbrella. And symptoms that he has reported, as well as past evaluators have observed, is some difficulty with learning and retaining information. And he has reported the same, as well as some attentional deficits. So I provided an unspecified diagnosis just due to the lack of collateral data and formal testing.
And someone with, well, and given the mental health profile you've just detailed of Mr. Wasser, could he have problems with retention and recalling information?
Yes, that would really be the definition of the learning disorder, is that individuals with this diagnosis would have difficulty learning and retaining information. However, once they do acquire that information, it is typically held within the long-term memory. So, for example,
So they're using learning disorder to say that he can't understand what's going on, but he's proven competence before. I understand what a juror is. I understand what a judge is supposed to do. I understand my crimes. I understand what the prosecutor's going to do. They're saying he has a learning disorder. Okay, that just means we have to go the extra mile to teach him what all these terms mean. But once he knows what all these terms mean, then the learning disorder would, you already know the stuff.
when I mentioned that Mr. Wasser was able to demonstrate all of this legal knowledge in February, there would be no real explanation as to why he suddenly lost that knowledge. That's not consistent with a learning disorder.
I mean to interrupt, Judge, but it does appear that Mr. Wasser may be asleep.
Mr. Wasser,
No, I'm not sleeping. I'm listening to you guys.
Okay, sometimes it's hard to
I'm
tell.
wide
We
awake.
believe you. Yep, okay, next question.
Okay. And I guess would Mr. Wasser, having those, I know you touched on this, but having that mental health profile, is it possible he would at times be able to retain and recall information and at other times be unable to?
I don't think that would be in line with a learning disorder or an ADHD diagnosis. Again, individuals have difficulty learning the information. They require additional supports or different methods of that information being provided. For example, information being written or presented orally. However, once that information is learned, it's typically held within long-term memory and then accessible.
I'm going to go into a bit of detail with some more of your report, specifically about your, your evaluation of or your interview with Mr. Wasser, or interview and evaluation. I'm looking now on page 5 of your report. When you asked Mr. Wasser about plea bargaining, and he said it was, quote, when they throw you a deal, did he provide any more detail as to what the plea bargaining process is?
And just to clarify, on page 5, that's actually a summary of the prior evaluations.
Apologies.
That's okay. But if you don't mind, I could follow up on your question regarding his understanding of plea bargains with me.
Yeah, please.
Okay. So in my interview with Mr. Wasser, he identified a plea bargain as something that they offer or something. He was quite vague in that response. And he believed that an offer was made by the judge. Mr. Wasser was receptive to corrective feedback and understood that the DA may offer a sentence such as time. However, follow-up queries regarding his understanding, even after being provided a tutorial, were I don't know or I can't understand types of responses.
And then
So lies.
I see that, and now I'm moving forward into your evaluation. When you asked Mr. Wasser about the charges and maximum penalties, is it true that when you first asked him, he did not know he listed some of the charges, but not all of the charges, and did not know the maximum potential penalties?
Yes, that is what he said, is that he did not.
Come on, that's not fair. How many people that come in front of the judge, even though they hear their list of charges and they hear the maximum penalties, can recite it back? None. They're all competent.
No.
And then during your interview with him, you told him the charges and maximum penalties a few times?
I'll clarify is that when I first asked about his understanding of why we were meeting, that's when he claimed he did not know the charges. However, when asked specifically to identify them, he was able to provide responses indicating his understanding of a disorderly conduct charge, that he did have a felony, and that one of his charges involved something with a gun. I did then provide him with education. I listed those charges and the penalties for him, after which, when his retention and understanding was assessed, he again provided brief responses saying disorderly, concealed something, terrorist, and a THC one.
And how much time passed between you telling him those and him telling them back to you?
In that section, I'd assessed his initial understanding of the allegations as well, and then reviewed his comprehension and retention. So I would estimate maybe 2 or 3 minutes had lapsed. And
then when you were speaking with Mr. Wasser about the parties in the courtroom. Was he able to provide further detail when he stated there were the other people and us when he's talking, I assume, about the state and defense?
No, he did not.
And did he provide understanding of the trial process?
No, he largely denied understanding the purpose of a trial or what occurs during a trial.
Okay. And when you spoke with Mr. Wasser about how he intended to plea and handle his pending charges, did he exhibit an understanding of what, or no, did he know what he was going to do?
Not explicitly. He did express that he would like to get the case dropped, of course, but he was not willing or able to elaborate on how that could occur. For example, which plea he would have to enter to potentially fight the case at a trial. I therefore asked him specifically if he wanted to take the charges in the case to trial or whether he'd be willing to consider a plea bargain. When asked about the trial, he said he just wanted to get the case done, indicating disinterest in that. And he said he was possibly open to plea bargaining if it involved probation.
Okay. And did Mr. Wasser tell you that a plea bargain involves an offer for a reduced punishment, or was that in a prior competency evaluation?
If I could just have a moment to review what I wrote. Let's see here. He understood with me that the district attorney, for example, could offer a sentence including less time. In prior evaluations, he was able to elaborate more on the plea bargaining process and specifically apply that to his past case.
And in the review of the prior evaluations, well, let me strike that. So my understanding is you believe he's competent because putting together through all of his prior reports as well as your evaluation of him, collectively, he's shown sufficient knowledge of the requirements to be competent. Is that right?
Yes, it would be a combination that he has demonstrated this knowledge across evaluation points, although it has been piecemeal, as you've mentioned. Additionally, I believe at least 3 evaluators, myself included, have had concerns about his effort and motivation to demonstrate his knowledge.
And has he, in any of the evaluations, had all of the pieces together and expressed that to an evaluator?
Yes, in February 2025, at the time that he was opined competent to proceed, he demonstrated, according to his evaluator in that report, intact legal knowledge. And the evaluator opined that he demonstrated a factual and rational understanding of his case. And
I wonder what happened with that case. I mean, I wonder if he took a plea, if he went to trial, if he was found guilty.
The court proceedings.
And so is it fair to say that in the 4 other evaluations you reviewed, as well as your evaluation of him, he did not have the kind of complete understanding?
That's correct. It was really that February case that he demonstrated everything all at once. In other evaluations, it has been piecemeal.
I have no further questions.
Anything else, Attorney Granberg?
Just a couple follow-up, Judge.
Okay.
Doctor, can individuals have mental health disorders and still be competent to assist in their own defense?
Yes.
Do you believe that to be the circumstance in the present case?
I would clarify that Mr. Wasser does not have any history of mental illness. He does have reported diagnoses on the neurodevelopmental spectrum, such as the learning disorder and ADHD, as well as a behavioral disorder called oppositional defiant disorder. As I mentioned, I do not believe that the symptoms of these conditions are so severe as to preclude his adjudicative capacities.
Thank you.
Anything else, Attorney Rubin?
No, Judge.
Okay. The doctor be excused, Attorney Rubin?
Thank you, Your Honor.
Thank you, Attorney.
Except if I get arrested, Bobby. Then the plea bargain's a good way to go.
Attorney Grammer, that's okay.
Yes, absolutely.
Thank you for your time, doctor.
Thank you.
Any argument, Attorney Grammer?
Judge, I think the doctor testified based on all of the prior evaluations she was able to review, as well as her own, that it's pretty evident that Mr. Wasser is, as she noted, more oppositional than anything. That doesn't mean that he is unable to assist in his defense. It just means that he may not be willing or have the capacity to be willing to assist in that defense. The standard is that he has sufficient mental capacity to understand the proceedings and assist in his own defense. And I think based on the testimony, as well as the incredibly well articulated report that was created by the doctor, that has been met. And I would ask the court to find him competent.
Judge, I don't believe that, or rather the state has not met its burden to prove that Mr. Wasser is competent by a greater weight of the credible evidence.
Think about it this way, Bobby. When my children were like 4 and 2, the 2-year-old would walk up to the 4-year-old and punch her. That's assault and battery. Should that 2-year-old go to jail? No, 2-year-old doesn't understand any of it. So competency, not just competency, mental health issues are like that. They don't understand. They need something different than jail. Although I did want to put my kids in jail a couple times, I'm not gonna lie.
As Dr. Kreikeberg noted, he has been evaluated 6 times, 5. Well, I'm not sure if he's been evaluated outside of what she reviewed and her evaluation. However, she reviewed 5 evaluations as well as one today, or her evaluation, and he once demonstrated sufficient knowledge of the court system in its totality. Judge, with his neurodevelopmental disorders, I'm not entirely sure how he would express that he doesn't know or understand the process, other than saying he did not know to her when asked. I would also note that in her report on page 8, she's talking about the plea bargaining process that she talked about with Mr. Wasser, and he stated, this is the bottom of the second paragraph, that he recalled the worst possible outcome for his case is that he goes to, quote, jail for like 3 years. That is not accurate with the charges he's facing, and that's particularly troubling considering that his maximum sentence here could include a prison sentence. Additionally, Dr. Kreikeberg noted this is in page 10, in this second paragraph, that there's no evidence presently that Mr. Wasser's cognitive capacity have posed a significant barrier to his daily functioning. However, she also noted in this is on page 3, the family social history, that Mr. Wasser reported his mother is his legal guardian. I believe looking at the totality of this report, as well as the fact that Mr. Wasser has been found incompetent numerous times at this point, combined with the doctor's testimony that he has difficulty learning it and has difficulty learning, excuse me, given the neurodevelopmental.
No, it won't, T. I have an idea for that. Just as we have perks, the psychiatrist will need lots of perks. Donuts, tacos, margaritas, you know, non-alcoholic. What they do with their non-alcoholic margarita is up to them. But we'll give them lots of food. We'll just keep throwing food at them. I feel if you work at a job where you get fed all the time, you stay there.
And other learning disorders that he presently lacks is incompetent. For those reasons, Your Honor, the state has not met its burden.
Okay. Well, I think I can come by the impression that he has some difficulty learning. That's not real difficult, but what is tending to override that as a sort of dominating impression, to use that word again, is the doctor's testimony, especially when she said it in two different ways. I think that, you know, she has concerns, and she shares concerns with other examiners about this idea that he is unwilling to demonstrate knowledge. That's very different than, you know, learning something and retaining it, which I'm satisfied that he has sufficient ability in that sort of subsector here. But he may have a learning disability. There may be, you know, a neurodivergent challenge here that he deals with or has had to deal with. But that it's just not having a whole lot of impact in in terms of legal competency and the doctor's opinion and how she arrived at her opinion. What did you said something about? Well, how would he tell her that he can't? Let's see here.
That is dumb, Kelly, because you can't really see anything when you go into the bathrooms. You don't see anything.
He said, I'm not entirely sure he would express that he doesn't know or understand the process other than saying he did not know to her when I asked. But I guess I don't understand why you, Attorney Rubin, would think that concern from your standpoint is significant in relationship to, again, her concern about him just resisting, or not resisting, but not willing to demonstrate to her during the examination that he, you know, has knowledge. So I mean, the burden here is by the greater weight. It's essentially a preponderance burden, but it's a greater weight of the evidence. And I think I mean, I don't have any concerns about the doctor's methodology or credentials, and I don't think there's any breakdown in like her opinion and you know, the way it was arrived at here. And so I think the state has met its burden. The court will make a finding of competency as of this time, again, based on the doctor's testimony on that report. And so, what do you want the matter set for now, Attorney? He wants some time to talk to your client.
Your Honor, I would request we be scheduled for a status conference.
Judge, I do think we are pre-prelim as well.
Want to just put a prelim on the calendar or a preliminary hearing schedule on the waiver, Attorney?
Yes, Judge.
preliminary hearing on, are you available as soon as May 19th in the afternoon?
Hi, CJ.
Yes, Judge,
Okay. 2:30?
that works.
2:30 on May 19th, that we're setting the matter for preliminary hearing.
We're going to have a charge issue, yes or no? It's kind of
I left this part in because the lawyer keeps unmuting it for some reason. He's holding the remote in his hand that mutes it and unmutes it. He keeps unmuting it.
get that from the what office was that? You're currently unmuted.
Take up 26 CF 151 first, so that's Wisconsin versus Robert Spranzi. Good afternoon, sir. Mr. Spranzi is present. He's here without counsel. The state's appearing by Attorney Flint. Attorney Flint, victim rights compliance.
Yes, Judge.
And sir, you are Robert
Yes,
G.
sir.
Spranzi?
Yes.
Okay.
Bracken!
Sir, do you want to appear with an attorney next time you come to court?
I believe Jack Chavez is appearing with me.
Oh, Jack Chavez?
I believe so, yeah.
All right. Where's Jack Chavez today?
He's got a in custody defendant today, Your Honor.
Judge, Attorney Chavez is here. He has the other in custody person. I'm here with Mr. Daniels.
Oh, I'm sorry. I overlooked that. Okay, let me, sir, can you just go back to the gallery? I'll recall your matter shortly. Yeah, you can stay there, actually. Who's with you then, Attorney Crawford?
This is Ethan Daniels. It's a bond-only hearing.
Okay. That's actually what I meant to call first. So let's use 25 or 26 GF 504 to take up an Ethan B. Daniels who got arrested and now he is in custody. And Mr. Daniels, can you see and hear me?
Yes, sir.
All right. And so Attorney Crawford, what are you going to provide to this record?
I'm appearing on his behalf for the purposes of the bond.
Okay. And then Attorney Flint, you're appearing on behalf of the state when it comes to bond?
Yes, Your Honor.
All right. Mr. Daniels, can you see and hear me? Can you see and hear Attorney Flint?
Yes.
All right. Attorney Crawford, you think we're sight and sound sufficient?
We are.
We're sight and sound sufficient. Is there a statutory victim here, Attorney Flint?
Not at this time, Your Honor.
I'm just going to say it, Bren. It's unfortunate that you picked tonight and not Sunday night. Because that one was really, never mind.
Okay. Then your bond request?
Yes, Your Honor. We are going to need more time to file a complaint. In the meantime, we would ask that the court set a signature bond. We're asking for a $10,000 signature bond with non-monetary conditions that Mr. Daniels have no presence at 129 Milton Street in Lake Mills, that he have no contact with any of the occupants of that residence, either, which is a duplex. This includes his grandparents, his aunt and her family, and the family dog. We ask that he have no contact with his girlfriend, whose initials are HJB, or his girlfriend's sister, whose initials are FPB. Thank you.
Attorney Crawford?
Your Honor, I don't object to the signature bond request. In terms of the no presence at 129 Milton Street, that's the address that I have for Mr. Daniels.
I live in a completely separate part, away from all of them.
Can you, one moment, please?
Sure.
They both.
Yep, their dog is going on the no contact order. He's not allowed to talk to the dog.
Sorry about that, Your Honor. Mr. Daniels just explaining the layout of this duplex. There are the 2 units, and then there is a basement apartment, which is where Mr. Daniels resides. He would like to be able to still reside at that particular location, even though it would potentially mean the no contact. I would ask for only incidental contact at this time with those individuals.
Would you be okay with that, Attorney Flint?
Yes, I would be okay with that.
All right, so let's see here.
We've seen cases where in domestic violence, the dog or the cat gets injured too. And I've never seen a judge put the dog or an animal in a no contact order.
Let me back up. So the court is going to admit to Mr. Daniels to bond that you need 30 days, or would ask for that 30 days to file a complaint, Attorney Flint.
Yes.
So that's we'll make a record about that being allowed. But for present purposes, a $10,000 signature bond. He's admitted to a $10,000 signature bond. Yes. And now the special conditions. Let's see here. How do we want to express this? No presence at 129 Milton Street in the city of Lake Mills, except that he can be present at that specific or defined location provided by Attorney Crawford.
Yeah.
And so that would be the basement apartment. I'm doing my best here, Madam Clerk, where Mr. Daniels currently resides. So he can be present there. He can reside there. But the no contact prohibition is going to be a special condition. No contact except for incidental contact. I think I used twice as many words to express that than I needed to. But do you think you have what you need, Madam Clerk? Or would you like some refinement?
Contact, is it no contact except for incidental contact with the occupants of the residence or the girlfriend and the girlfriend's sister?
It's an and for
Your
that.
Honor, we would ask that he have we would not approve of the objection of the exception regarding the girlfriend and her sister.
Oh, and I didn't mean to intend that. It's an outright no contact, Madam Clerk.
With the girlfriend and sister.
Correct. Sorry about that. Yeah, what you need, Madam Clerk? Okay. So, anything else, Attorney Flint?
No, Your Honor.
Anything, Attorney Crawford? Do you think we can make a record about Mr. Daniels knowing what to do if he wants representation if a complaint is filed?
Correct. I have provided Mr. Daniels with our office's contact information in the instance that if or when the state issues the charges. So he knows how to get in touch with our office for evaluation.
Do we know, Mr. Daniels, do you own or possess any domestic animals?
No.
Okay. Recess.
Judge, do we have a date though for the return on that, or is it just they have 30 days to file?
I should do a backstop some way. I don't know if that's a judicial review usually, or what do we usually do here?
Your Honor, usually the bond just lapses if we don't file the complaint within 30 days.
Okay.
That works.
Okay, that's okay, Attorney Crawford?
Yes.
Okay. Were you expecting something else, Marissa?
No.
Okay. Recess.
I don't know, Brandy. I think you have 4 decisions. I think you have 4 different paths to take with your dumpster fire. And I'm wondering which one. I'm eager to see which way you go.
Thank you. I'll get Attorney Chavez.
Okay, thank you. Attorney Chavez, can you see and hear me? Yeah, you're on mute, Attorney Chavez. Do you know how to work that thing?
What's that?
What's that?
Hello.
Hello. Attorney Chavez, do you represent Mr. Spranzi, or is that
I
how
do
you pronounce
not, Judge. I do not represent Mr. Spranzi in any way, shape, or form. I did on a prior case.
Okay.
Nice try, Robert.
All right. No,
Said your name.
No, hang on.
My name, so I don't know.
Hang on, Robert. Let's see here. So we'll take up 26 CF 151. That's Wisconsin versus Robert G. Spranzi. Now, Mr. Spranzi, do you can't force a lawyer to take your case? So, I mean, you might have some understanding or misunderstanding, but do you want to get a lawyer for this case?
I'm not entirely sure. These charges, I think I already went to jail for and did my time.
Oh, well, let's see here. Mr. Spranzi, I don't think we can bring I don't know if I can process that addition to the record. So let's just start with the basics here. Do you have a copy of the criminal complaint?
I do not.
Okay, could you furnish him one, please, Attorney Flint?
I can try. I'm not the printer in here. I'm not sure I'll be able to connect to, so give me a second.
You bet.
I did see it on CCAP.
You did? You saw the complaint on CCAP?
Well, I saw the charges,
Okay.
I should say.
Okay.
They're from April, which
Okay, hang on, Mr.
of
Spranzi.
last year.
Yeah.
Oh,
Let's
it's
see here.
storming so hard
So once
here right now.
once you get a copy of it, do you need me to read it word for word?
No.
Okay.
I just
So
think there's been like a mistake that was made here because I
okay.
was put on probation for all these charges
Okay.
before.
All right. That won't go unexamined. But just for today, we just have to do
Okay. All right.
some early procedural things. So it says your address is at the jail, but I don't think it is. So where do you take your mail, sir?
12.
Okay. Is there a unit number associated with that? Your date of birth, August 3rd of 1983?
Yep.
Okay, so I'm going to summarize the allegations here. They're allegations. The first one is retail theft, alter price, amount greater than $500 to $5,000 as a repeater on April 2nd, 2025 in Watertown, Jefferson County. That's an I felony, and it's ordinarily punishable by a fine of not more than $10,000 or imprisonment for not more than 3.5 years or both. If the state proves you're a repeater, then the maximum term of imprisonment could be increased to not more than 2 years. The other count, it's the same count, but it's separate and distinct. So there's two allegations to the effect of retail theft, alter price greater than $500 to $5,000 as a repeater. The second count, again, alleged to have occurred on April 7, 2025 in Watertown, Jefferson County. It's an I felony, punishable by a fine of not more than $10,000 or imprisonment for not more than 3.5 years or both. And there too, if the state proves you're a repeater, then the maximum term of imprisonment may be increased to not more than 2 years. So, Mr. Spranzi, do you understand what you're accused of right now and what the maximum penalties are if you were to be convicted?
Yes.
Okay. And do you want you have a bond request, Attorney Flint?
1 second.
Sure.
Yeah, I've tried like 7 different printers.
Okay.
So, the state is requesting a $1,000 signature bond with the non-monetary condition that the defendant have no presence at the Walmart in Watertown.
Okay. Now, Mr. Spranzi, just on that subject of bond that the state has requested, do you have any objection?
No.
Okay. So that will be the bond in this case. As soon as we're done here, Mr. Spranzi, you have to go over to the clerk of court's office to sign that bond.
Mm-hmm.
And just confirm here in a moment, sir, that you are in receipt of that criminal complaint. You got it now?
Mm-hmm.
Is that a yes?
Yes, I'm sorry, yes.
Okay, and you still don't want me to read it word for word?
No, that's okay.
Okay, so we'll, so Attorney Chavez doesn't represent you. Do you want to go out and get a lawyer privately, or do you want the court's support in getting you a lawyer? I mean,
I'll take a public defender if available, but yeah.
okay. Well, we can start that way. It's up to them whether you're eligible. They'll determine that. So what you have to do, sir, is by noon on Monday, you have to contact the public defender's office, their local office here in Jefferson. You can go there in person, or you can call them at 920-674-2800. They'll evaluate you. We'll put that on paper. We'll put that. Yeah. So if you're not eligible for a public defender, then the county can provide you a lawyer. Yeah. But in order to do that, you have to fill out this document that the clerk will give you. It's called a petition or an appointment of an attorney. You fill that out, you submit it. If you're not eligible for a state public defender lawyer, then the lawyer or the courts will provide you a lawyer at county expense. Understand?
Yes.
We'll toll time limits for speedy prelim given the need to get a lawyer in place, and we'll come back to court, Mr. Spranzi, in probably the month of June.
Can I request that any court date scheduled for me be on a Friday, please?
You can for the next one. I don't know if we can accommodate that
Thank you
for the duration of the case. You can always consider it. So Fridays are better for you, sir?
It's the only day of the week I have off.
Oh, okay.
And I got a strict work schedule. They're pretty weird about it.
They're getting weird?
Yeah, they don't like people leaving early.
Okay. You can come back to court on Friday, June 19th.
It did.
But it's going to have to be the morning.
Anytime.
10:40. Okay. 10:45 on June 19th. Even if you don't have a lawyer, be sure to come back to court, and then we'll work on that. But you have to come back to court on that day at that time. And we'll see if you want a speedy prelim and go from there. Anything else, Attorney Flint?
No, Judge.
Okay. Anything else, Madam Clerk?
No, Judge.
Okay. All right. Thank you, sir. Recess. And now we'll call 25 CF 204. That's Wisconsin versus James Richard Harris. Mr. Harris is in custody. He's going to appear by remote means, video conferencing using Zoom with audio and video. I think it has been working. Mr. Harris, can you see and hear me?
James, thank you so much. I appreciate it.
Yes, I can.
And Attorney Chavez, you're appearing on his behalf from that location.
Yes.
And Attorney Flint, state your appearance, please.
The state appears by Attorney Melanie Flint.
Whoops, sorry about that. Mr. Harris, can you see and hear me? Can you see and hear Attorney Flint?
Yes, I can.
I have an
Sight and sound sufficient, Attorney Chavez?
Yes.
I love breakfast. I love dinner. And I have an affection for lunch.
Sight and sound sufficient. This is a return on warrant. Looks like there was an initial appearance. Maybe not. Yeah, there was.
Yes.
All right. So he's now before the court. Do you have a request or record to make, Attorney Flint?
Yes, Your Honor. The state is requesting a $500 cash bond in this case. The defendant has now missed 2 court appearances, the last being on January 13th of 2026. So this case has been in warrant status since that time. I will note that the first status date he missed was on December 29th. His original hearing was scheduled for December 30th, and that is the court date he was given when he was in court, but the court did not have a calendar on December 30th. So he was sent a notice that the court date was December 29th. That notice was never returned. The court then stayed the warrant until the next hearing, which was set for January 13th. Another notice was sent to the defendant. That notice was not returned, and the defendant did miss that court hearing. So for this reason, even though he may have had an excuse for missing that first hearing, we do believe that he was provided adequate notice of the second court hearing. And we do believe that given the missed court appearance, cash is now necessary to ensure future appearance, and we are requesting $500. Thank you.
All right, Attorney Chavez.
I hope so. Mr. Harris has had trouble at home with his family. His mom recently passed away, and now the father refuses to come out of the home. And he's having all sorts of health issues. So he's been focused on that, and also finding a place to live. And he finally landed with his sister on Horde Road, which should probably be updated sometime during this hearing. But it was never intentional by any means. I'm asking that the signature bond be reinstated.
Okay. Well, let's see here. Is it West 635, Mr. Harris? Is that where you take your mail?
Correct.
Okay. All right. Well, let's consider the request for cash. It's not unexpected that the state would request cash at this point, given the missed court appearance. There is an explanation now on the record about what happened on the 29th that I think diffuses
Mouth, face, throat, stomach,
a
ass.
super high concern about keeping Mr. Harris answerable to the proceedings in Branch 4. It's really that last miss that is of concern. And the court does believe a small amount of cash is warranted now to ensure future appearances. It's a felony case, and I heard about other priorities in life, other exigencies, and those aren't lost on the court or other people. But I think, Mr. Harris, you're going to have to add this to sort of high priority category. And then if you can't get to court, or if, you know, life circumstances are such that it's just not in the cards, then you got to let your lawyer know, or you appear by Zoom or something. Those accommodations are pretty forthcoming. So the court's going to require a $100 cash posting, no change to the special conditions. Those will continue. Is this pre-prelim? No. So, what do you want on the calendar next in Branch 4, Attorney Chavez?
Is this post prelim? I can't recall myself. It's been a while.
It is. I just confirmed it's post prelim as of.
He's mellow, but if you listen to him, he has sharp bars in there.
Status
in Branch 4 in what, June?
Yes.
Is that okay by you, Attorney Flint?
Sure.
Okay. June 2nd at 1:30.
We don't care when it is. I know the answer is no. I know it. But if anybody is watching from Wyoming, could you drop a comment or come into chat and say, hi, I'm from Wyoming? I think there's zero people from Wyoming. And I'm just curious. Population of Wyoming is not high. All right, so the dog will be safe, but what if you can't go to McDonald's anymore?
Okay, so I did find probable cause for your arrest. We are here to address bond in your matter, and I'm going to hear first from the people. Mr. Finnegan?
Based on these statements in the affidavit, where it appears that Mr. Lopez is intent on committing more crimes against the arresting officers, as well as that there appears to be a community safety risk for anyone who comes in contact with it, whether that's in a gas station or at a liquor store. I'd also note that 8 of his 13 failures to appear have occurred in the last 5 years. I would be asking for a $10,000 cash only bond here, as well as contact order with the officers listed.
All right, thank you. And Mr. Finnegan, if I could just have you pull your microphone closer to you, I'd appreciate that. Mr. Morris?
Mr. Lopez does not have any cash available to him, does not have a co-signer available to him. He is not working right now and currently does not have a fixed residence. So I think the only thing that might secure his release is a personal recognizance bond. That would be my request here.
All right, thank you. So I do have significant concerns for community safety. Given the nature of the allegations contained in the affidavit, there's an indication that there was law enforcement contact based on erratic behavior, and ultimately Mr. Lopez allegedly damaging a business.
Give me a second, guys.
No.
Give me just a second. So I ran out of, I need a stick of RAM pretty badly. I just do. So I'm gonna keep Twitch off. You guys already got your streaks and everything in Twitch. Monica, if you want me to start Twitch again, I will for you. But if you don't need it, I'm not going to start Twitch again. I'm just going to keep it off. It's good. We just, it was a slight hiccup. Let me just back it up a few seconds. So we're back. We're good. I think we're good. So I'm going to press play. Sorry.
Here to address bond in your matter, and I'm going to hear first from the people. Mr. Finnegan.
Based on these statements in the affidavit where it appears that Mr. Lopez is intent on committing more crimes against the arresting officers, as well as that there appears to be a community safety risk for anyone who comes in contact with it, whether that's in a gas station or at a liquor store. I'd also note that 8 of his 13 failures to appear have occurred in the last 5 years. I would be asking for a $10,000 cash only bond here, as well as a contact order with the officers listed.
All right, thank you. And Mr. Finnegan, if I could just have you pull your microphone closer to you, I'd appreciate that. Mr. Morris?
Mr. Lopez does not have any cash available to him, does not have a co-signer available to him. He is not working right now and currently does not have a fixed residence. So I think the only thing that might secure his release is a personal recognizance bond. That would be my request here.
All right, thank you. So I do have significant concerns for community safety. Given the nature of the allegations contained in the affidavit, there's an indication that there was law enforcement contact based on erratic behavior, and ultimately Mr. Lopez allegedly damaging a business window by throwing a wooden pellet through it.
So when they say he threw a wooden pellet through the business window, does he mean a pallet? Like a wooden pallet? Do you think he picked up a wooden pallet and threw it through the window? Because to me, a wooden pellet is a little tiny thing. But I don't know.
And I do have victim safety concerns as well, just given the alleged statements to different officers. It's very concerning. So for those reasons,
I have to move. It's imperative. It's critical. It's beyond critical. I have to move right now. I did find a house today. I don't know if I have everything I need to get this house, but spending money on RAM right now is not possible. I have to move.
I do find that a monetary bond is reasonable and necessary. I do find that a $10,000 cash bond to be appropriate. Sir, as conditions of bond, I am going to require that you remain law abiding.
He said he threw a pellet through the room, not a pallet. I think he meant pallet, though.
I am going to require that you report to pretrial services within 24 hours of your release. That will be for their enhanced supervision. The court will authorize MIPS. Sir, I do have to issue the mandatory restraining order under Title 18, and that states that you shall not harass, molest, intimidate, retaliate against, or otherwise tamper with any victim or witness to this matter. In addition, the court is going to order that you refrain from having any contact with the listed locations, the Valvoline Instant Oil Change location in Fort Collins, as well as the Mulberry Max Liquor location in Fort Collins, and you're not to come within 10 yards of those businesses. So your next court date is going to be May 20th, 2026, and that's going to be at 8:30 a.m., and that'll be in courtroom 5C.
Yes.
Thank you, sir.
Judge, can you re-explain this bond to him, please?
Yes, it is a cash bond, a $10,000 cash bond.
10,000 cash bond. Thank you, sir.
All right, thank you. All right, next the court will call 26 CR 682. Mr. Laubin, did you understand your rights on advisement?
Yes.
And are you a current member or a veteran of our military?
No.
So I did find probable cause
Yeah,
for
it's a good
your
point.
arrest. So we are here to address bond in your matter. Charges have yet to be filed. I'm going to hear bond arguments first from the prosecution. Mr. Finnegan?
I'd be asking for a $10,000 cash surety bond in this case, noting that he was on a $8,500 cash surety case or cash surety bond related to trespassing to the same building. Noting that this also involves targeting a protected party's belongings as well. I think that the increased cash surety bond would be appropriate here.
All right, thank you. Mr. Morris?
Yeah, as explained in the bond application, he does have a job. Mr. Lobbin has family in the area. He has a stable place to live in Berthoud with some roommates. I don't believe he's in a position to post another cash bond. And so my request here is that the court set some sort of recognizance level bond.
All right, thank you. So I do have concerns for victim safety in this matter. It is concerning reading the allegations contained in the affidavit. And I did
Sir.
note as well.
Dear sir, if the judge says they have concerns for victim safety, don't agree with him. That's not your time to go, Judge, you're right.
Pretty limited criminal history. However, 5 prior failures to appear and 2 prior failures to comply give the court concern with respect to Mr. Lobbin's willingness to comply with court orders, not to mention the likely violation of restraining order charge that will be filed in this matter. And the court did note that Mr. Lobbin does have pending Class 6 felony criminal trespass charge. There was a recently cash surety bond that was set in that matter in the amount of $8,500 that was posted. And then we have these allegations before the court. So I do find that a $10,000 cash surety bond is appropriate in this matter. And that is what I will be setting. Excuse me, sorry, as conditions of bond, I'm going to require that you remain law abiding. I am going to order that you report also to pretrial services within 24 hours of your release. That will be for their intensive supervision.
I was just wondering about the PR bond because I wasn't there like when I went to the building and everything like that. Like the tattoo was they didn't match. I had to file a sexual assault thing for that happened at around the time. And stuff like that for the people and everything like that. If you look up like the tattoos and everything that I have with like the evidence.
All right, sir. So I am just addressing bond in this matter based on the information that I have.
Okay. Yeah.
So based on the information that I have, again, I found that there was probable cause. And as conditions of bond, I do have to also.
Because, yeah, I just don't have any money.
I do have to issue a mandatory restraining order under Title 18, and that states that you shall not harass, molest, intimidate, retaliate against, or otherwise tamper with any victim or witness to this matter. And give me 1 second here. What I'm inclined to do, Mr. Finnegan, is instead of issuing a no contact order here,
It's not hard to learn to use an Apple product. If you get an Apple product, you'll be perfectly fine. They're both, either decision is perfectly fine. They're both fine.
Issue a condition of bond that he comply with the no contact order that was set in 26 CR 560. But do you know if you have quick access or in your notes that both parties are listed in that matter? Stormy Niles and Orion Niles. If you don't, I can look that up really quickly.
Don't talk to Stormy no more. That's what the judge is saying.
Yeah,
I believe it is, but
I have certificates saying I am ethical.
That protection order only lists Orion Niles.
Okay. All right, so what I am going to do is issue a no contact order here as well. So, sir, what I'm going to do in addition to that standard Title 18 restraining order, I'm going to order that you not have any direct or indirect communication, contact with Stormy Niles and Orion Niles. You must remain at least 50 yards from their persons or where they are likely to be.
Blood, sweat,
Without
and
any
tears, I earned
exceptions.
that. Blood,
So your
sweat,
next
tears.
court date is going to be May 18th, 2026 at 8:30 a.m. And that will be in courtroom 5A.
Okay, man. For bond and stuff like that, I was hoping for to like sign myself out or something. Is that what happening?
Judge, I know you said that my bond is $10,000, but I can just sign and leave, right? I can just, because the tattoo doesn't match, and I filed sexual assault, so I can sign, right?
Or
No, that is not what's happening, sir. I did issue a $10,000 cash surety bond.
okay, what's that? So I had to give like a bail bond or something.
That's right.
Okay.
All right, thank you.
Your Honor, this is Deputy Long.
Okay, we're about to get to the McDonald's portion of this segment, guys, and you know, it'll be fine. Don't worry. This is not happening to you. Don't worry.
Miss Karen Kimball has refused to participate today.
All right, thank you. Counsel, any objection to the court calling that matter up? She appeared yesterday, and there was an indication that might not have really resulted in a refusal per se, but there were some other issues going on. It appears that's different today.
Yeah, I don't have an objection to the court calling it up. I don't have input. I was unable to speak to Ms. Kimball, but I do think the court can and should set bond today.
All right. So the court will call up 26M 1210. This is the matter concerning Karen Kimball. Deputies informed the court that Ms. Kimball has refused to appear. So the court does find that that is a waiver of her right, not only her right to have bond set within 24 hours, but also of her right to be present if and when the court does address bond. I do want to address bond today. There were two charges, a class 1 misdemeanor criminal mischief, a class 2 misdemeanor second degree criminal tampering that are before the court. Mr. Finnegan, what would you like the court to consider with respect to bond?
I would just note that all 10 of her failures to appear have occurred within the last 5 years. I'd be asking for a $1,000 cash surety bond to ensure her appearance at future dates.
All right, thank you. Mr. Morris?
I don't have any input.
All right, thank you. So I do find that a monetary bond is reasonable and necessary despite the relatively low level charges here. The court's biggest concern are those failures to appear and failures to comply. There are 10 prior failures to appear, 11 prior failures to comply. So the court has very little confidence that she would appear when ordered to do so. I'm going to set bond in the amount of $2,000 that will be a cash surety bond. As conditions of bond, I'm going to require that she remain law abiding and that she report to pretrial services within 24 hours of her release for enhanced supervision. The court will authorize MIPS. Part of that supervision will include their monitoring of Ms. Kimball's sobriety is directed by pretrial services. The court will authorize random UAs and will order that she not possess or consume any alcohol, drugs, or recreational marijuana. While on bond, the court will issue the mandatory restraining order under Title 18 and will order as well that she refrain from contacting the McDonald's and coming within 10 yards of that business, which is at 1675
So she didn't go to court. Now she can't go to McDonald's anymore. Zach, I'm sorry. I'm wrong. I have 187, which might be some duplicates because remember I downloaded them twice and I got rid of the duplicates. I might have missed 10. So I think we're good. She didn't come to court. She's not allowed to go to McDonald's anymore. Now, I don't know how I feel about that. So being a single mom, McDonald's saved my life. so repeatedly that I don't even know how to say it. Single mom, 2 jobs, and I went to college, got my master's degree. McDonald's was there for me, and McDonald's used to be cheap and delicious. Like it tasted good when you ate it. Now you go to McDonald's and it's super expensive. It's more expensive than sitting down at a restaurant. And it tastes like crap right now. It's just, none of the food is hot or fresh. Maybe it's just around here. But, I mean, it's just, McDonald's used to be, you know, you got that cheeseburger, yum, yum. Now it's like, the cheese isn't even melted and there's ketchup running down the side. I don't know what's going on with McDonald's. I don't know. But, I don't know. She's not allowed to go to McDonald's anymore. My kids are grown, so that wouldn't bother me. Let's see if, let's do this one. I know there's no sound. Give it a second. Let's do a different one. I think I made a mistake on that one. Speed trial.
Banks. Mr. Banks has got clause numbers 2410 F5351 and 2602 F6178. 178 is set for jury trial on 6/11. The state's subs are out. We're here for a pretrial conference on that matter. Mr. Waneke, your thoughts?
Yes, Your Honor. I have had some discussions with Mr. Wexler regarding this matter. I think if we can get one further record date, for him to review some things, and we should have an idea of where we're heading.
Excuse me, John. That's the committee that I attended.
What's going on? That Mr. Banks?
That's Mr. Banks right there. Yeah.
Is there anything I can say to you?
Well, it's usually best to speak through your attorney, but
yeah,
it appears that there's still some negotiations going on, which is what today is about. It's supposed to be wrapped up by today, but
maybe is there any way you can tell me the criteria on the SP trial, please, Your Honor?
well, that's a decision your attorney has to make, because only he knows if he can be ready for the speedy trial.
I understand that.
But you've got a trial that's set. You've got a trial that's set for June 11th, which if you make a speedy trial motion today, then you've got 70 days from today to get it resolved, and that's in 30 days, not 70. So there's not going to be anything for you at this point.
I asked them if I can get it. Well, but it'll be resolved on that day. There will be no more pushing it back.
As of now.
So it'll be 30 days, and that'll be the final for the trial.
The trial's set for June 11th, sir.
Oh, I'm not trying to ask you or nothing.
Yeah, no, I'm just telling you it's set for June 11th.
No, I appreciate you. Thank you so much for your time and your patience. Yeah, I'll take that, because I just want to get it resolved, because this is the first time in my life I've never done anything, Your Honor. I go straight over.
Okay.
And,
Mr. Banks, that's enough.
Yeah.
No.
We don't need to be discussing what did or did not happen.
The case, sir.
All right, I'm sorry about that, Judge Monk.
No, it's okay. It's okay. It's just the problem is that it's all being recorded and can all be used against you at a later date.
I understand. I've been doing great out there. It didn't pass that. I mean, I didn't fill out one drop. I've been doing great. I just discharge is focused. And I have a doctor's note for when I missed your court too.
Mr. Banks, we're not resolving it today, sir. That's all good stuff, but your attorney will want to use that later. Okay.
Oh, okay. Can I say this, please? No, my mom, please, just a little bit slightly.
We need to talk about that at the end of the hearing.
Okay, thank you, sir.
So we're set for June 11th. Are you asking for an intermediate for the record, Mr. Waneke?
Yes, Your Honor. I discussed with Mr. Wexler to take a look at the videos here and see if we have a determination on this matter.
What do you?
I think if we just need next week.
I mean, if you want to come back as early as Thursday, I can get it done by that. I mean, it's not going to take long rounds.
Okay.
And I think, we'll still likely have
Thursday the 14th
probation violation.
I'm doing great.
Okay, we'll come back on Thursday the 14th and know for sure what we're going. take to trial in this case. All right.
You want to,
Hello,
Okay,
power
good. We'll come
slinger.
back on the 13th, confirm that, and have the state have a chance to review some things your attorney pointed out to him. And we'll settle that. Okay?
And we'll see how much.
But Judge, I want speedy trial. I want speedy trial, Judge. Your trial is in 30 days. I want speedy trial. If I give you speedy trial, your trial will be in 70 days.
Yeah.
Thank you.
That's wrong. That's the end of, can I please get a little slight bond reduction, please?
We'll take that up on Thursday.
Thank you so much.
That could change, Thursday could change the landscape. That's what I'm saying.
So just please have a good day. Thank you.
All right. All right. Thank you. Thank you, Mr. Chairman.
Can I just get a bond reduction then? Can you just give me something? I don't care what. Just give me something.
David Zacher?
Mr. Zacher's in custody.
Don't trust no Zach.
He has relieved me of my representation. I'm also not willing to accept representation on the new case.
When you say the new case, what are you referring to?
He has a case that was transferred out of county because apparently they filed habitual DV and refiled. They dismissed the misdemeanor, refiled it as a felony.
Do you have a case number?
Yes, Your Honor, that's 26 CR 1818.
All right, so does that mean I need to schedule him for a conflict hearing?
That's up to the court. I can tell the court that he has this new case. I am not willing to accept appointment. And on the old case, we can have a conflict hearing. He has indicated that he does not want me to represent him anymore, and I am going to respect that. This is, I'm thinking, I'm his third.
We might be able to skip the formality of a conflict hearing, given that there's a new case.
Sure.
That help me appreciate which case is the driving case here. Is it still the 24 CR case or is it the 26?
I don't know. By driving.
Well, what's going to likely control the negotiations?
Yes, Your Honor, I can tell you that 24 CR 5133 is still pre-adjudication. We are set for trial in that case. And so I think that would probably be the driving case since it's been pending for quite some time and we've been unable to resolve it and it's set for trial.
And I can let the court know.
We're likely to run into some complications getting a new attorney with a case already set for trial.
There's also an issue that he's had Ms. Maniscalco, Ms. Chatterton, Mr. Anaya, and then myself.
As well as the public defender's office.
Anybody have any suggestions of? It sounds like Mr. Zacher wishes to speak to me. Mr. Zacher, I'm happy to listen to whatever you have to say, but first I have to remind you that we're recording everything that is said here in the courtroom. And if you say anything about your case, that it could be used against you by the prosecution. And so
I understand. I just wanted to note that I was told in Division 23 last week that I would have a new appointment of counsel at this hearing today. Aside from him, I per our last conversation, I didn't want him representing me because he said nothing to help my case. And honestly, my rights have been violated for speedy trial in
My rights are violated.
the main case, and haven't had adequate counsel the entire time.
Mr. Cook, are you available to accept appointment? This is Mr. Zacher. If you have a copy of the docket, you can see that he has two cases and you can see the charges there. Mr. Zacher, let me tell you what is probably obvious to you.
I don't have an adequate housekeeper here.
You have the right to a speedy trial and you also have the right to be represented by conflict-free counsel. Sometimes those two rights can be in tension with each other, and we have typically what takes precedence is we sometimes have to reschedule the trial so that your new lawyer can come up to speed. Do you understand that?
Yes, but the one thing I'm not understanding is that I pleaded not guilty in December of 2024, and I was prepared to go to trial with Kara Maniscalco and the previous attorneys. They weren't prepared, and it was all based upon the competency evaluation. Took them 9 months to complete the competency evaluation. As a direct result of that, my rights to a speedy trial have been violated.
Well, I disagree. And the reason for that is that during a competency evaluation, the speedy trial period is told. And so that time doesn't count pursuant to Colorado law.
The speedy trial, I mean, the competency evaluation was conducted last October. And then it's been well over 6 months since they completed the evaluation.
Then Ms. Matakowsko with Mr. Zacher, well before I was on the case, withdrew not guilty pleas. And so, as I've expressed to Mr. Zacher, I have no control over that. I can't do anything about that. That has nothing to do with me. I don't have any.
Its concern, Your Honor, is that Ms. Maniscalco refused to even investigate the case. I didn't even review discovery with him and his staff until last March. I haven't even reviewed the evidence against me in this case for over a year and a half.
So here's what I want you to understand. We have to take these things in order. And the first step is to get you a new attorney and then to give that attorney time to investigate those issues so that that attorney can file any motions that might be relevant. So let me ask the prosecutor on Mr. Zacher's case, do we have a speedy trial clock ticking as far as you're concerned?
We do have a speedy trial the speedy trial clock ticking. It looks like we are currently set for trial on August 10th with a speedy of October 7th. So we do have some time. It's not coming up super quick.
And I can tell the court that my office has done extensive investigation into this case. And so we have all the investigation that we could provide, or not all, but a significant amount of investigation we can provide to whatever attorney is taking over the case.
Okay. Mr. Cook, I don't mean to put you on the spot. Are you able to assess the situation and give me an opinion?
Yeah, I could do it, Your Honor. I know it sounds like you're in need of an attorney on this case and have had a few, so I could accept appointment. I'm already booked up in August. I can't accept that date. I would probably need to go into probably late September or August or October for trial.
All right.
What you did,
when
sir?
is the speedy?
See what your shenanigans did? Now it's going to take months longer for you because of all of this.
Trial running again, Ms. O'Rear?
October 7th is our current speedy trial deadline.
That would be perfect. I'll stay in the shed.
So let's see if we can find
I
a
would love
date
it.
on your calendar, Mr. Cook, that is within the speedy trial period that's presently scheduled.
You can tell all your friends about the mean old lady in your shed.
Is this a 1 week trial?
Yes.
Is it anticipated? Okay.
About September 14th.
Monica, that was totally a
I
secret.
think I can do that. When is judicial conference? Is it the week of the
Tell them that
21st of
after I
September?
move in.
Okay. Yeah, I could do the 14th, Your Honor, the week of 14th and then presumably the 16th and 17th of that week. I can do that.
Can the people accept September 14th?
Yes, Your Honor, we can.
All right, so we're going to vacate the August date and reschedule the trial for September 14th. Mr. Cook is your new attorney. He's going to need to get the police reports and the investigation that Mr. Lowe mentioned, and then he'll be out to communicate with you.
My main concern, Your Honor, is that Eric Anaya was previously appointed on my case, and the very day that my competency evaluation was completed and I was found fully competent and prepared for trial, he withdrew from my case. This should have been done back in last September. My right to a speedy trial has already been violated.
You can talk to Mr. Cook about that.
And as I said,
Mr. Zacher, let me explain something. Decisions do not get made in court just because you blurt them out in court. These things get investigated by the attorneys. If they believe there's a viable legal issue, They have the power to file the motion. We then schedule a date in court where the motion is litigated, and then you receive a ruling from the judge.
That was the whole discrepancy I've had with the previous ADC counsel that's been appointed.
Sure, but
Never filed any motions. They wouldn't listen to anything I had to say.
Mr. Cook is going to listen.
No, Judge, come on, Judge. Don't say that. Mr. Cook is absolutely not going to file the motions you want him to file. This is your fourth lawyer, and the first three did not file those motions because they're bullshit motions. And they can't just file them. Mr. Cook is not going to file them, sir.
And he will decide what to file. Thank you.
And I'm appointed on the 26 CR case as well.
Yes, both
Okay.
cases.
What is the posture of that appearance of counsel? Do we need to get a prelim date? Has that been waived?
Yeah,
What's
prelim, please.
And what is this the first appearance of that used to be in county court, Mr. Cook, and the people decided to file habitual domestic violence charges that turned it into a felony and brought it up to district court? Is this
12
the
years.
first appearance
Sentence.
on that?
Technically, the first appearance was the last court date, but then it was set here for appearance of counsel. I do believe we'll need to set for a preliminary hearing.
We need to get a prelim date then.
Okay.
Agree.
So the 26 case, we'll schedule preliminary hearing for about June 9th at 1:30.
That should be fine, Your Honor. And I'm going to need an ADC appointment order for both cases. And I don't know if I need a withdrawal order. We'll figure it out. All right. Thank you, Judge.
Hang on, there's one other thing I need to put on the record.
Okay.
I thought that what we were going to be doing here this morning was a conflict hearing with Mr. Zacher and Mr. Lowe, and we're not doing that because of the new case that came up from county court. The court is specifically ruling that because Mr. Lowe was not taking 26 CR 1818, I'm primarily appointing you on the 26 CR case, and then the rationale for giving you the 24 CR 5133 case is for continuity of counsel.
Understood.
Okay, thank you.
Thank you.
Oh, we still need to give you a pretrial readiness date?
Okay, that doesn't matter. Brent, you don't need gas. If you could just take over management of your boss's donkey, that's called work. Then he could just take you around everywhere you need to go. Yeah, I'm gonna say an ass riding an ass.
Okay, Miss Blaha.
I have Stephen Callan.
Yes. 25 CR 4061. Mr. Kalin is here out of custody with Miss Blaha for sentencing. For the people, we have Miss Robertson, and Mr. Kalin was present on March 16th. He entered a guilty plea to count 7, driving under the influence. It's a stipulation of probation with 60 days jail. We had a drug and alcohol evaluation performed, and I have real concerns about accepting this agreement and sentencing according to it. So I guess I'll just tell you what those are. It appears that when Mr. Kalin last used marijuana and cocaine, it was the same day as his plea was taken. So I don't know if he took that drugs before or after his plea. I also have a concern about the number of prior alcohol-related driving offenses he has. I also have a concern about his attitude about this case, that he said this plea is going overboard. I think it is an incredibly lenient plea, given given all of that. I've reviewed the probable cause affidavit. I recall when I took the plea that Miss Thomas made some kind of record about it, and I can't remember exactly what the record was. But I think in 10 years, I've rejected one plea, and this may be the second one I reject. I'm just very, very concerned about it. The history of driving while intoxicated, the fact that drug use was done on the same day that I have concerns about the plea itself based on that. And certainly Mr. Kalen's attitude about this. It seems very cavalier and not understanding the gravity of the situation. So Miss Robertson, anything?
No, Your Honor, we would defer to the court on whether or not to accept the plea.
Okay. I mean, is there anything you want to say about, I can't remember the record Miss Thomas made. I believe it was something to do with the merits of the case. I looked at the PC affidavit, and obviously I'm not weighing evidence or anything, but it didn't strike me as any major weaknesses in it. So
I'll be honest, Your Honor, I don't have a note from the prior DA about why we would have done that. So if Ms. Blaha knows, then that might be.
Ms. Blaha?
I think two-part. One, Miss Thomas was not ready for trial in discovery. We didn't have any prior or 3 prior certified.
I can't tell. To me, it looks like he has light color blue jeans on, but that could be part of the podium. I don't know. And his shirt is tucked in, so it's just a regular shirt. So he wore this shirt to court on purpose. Or that's blocking it off and that's prison garb. I can't tell. If I had a guess, he chose to wear orange to court. That's my guess.
Copies of convictions, which they would need at trial to secure a felony conviction. I'm looking in discovery now to see if they have it now, but I also don't see it now. So I think that was one of the bases, given that we were on the trial date, and these are at least one of them, I want to say, is a main fairly long ago. Yeah, most of them. At least one of them is a main conviction, but essentially we don't have any of the certified copies in discovery. And that was one of the bases why we were able to get a misdemeanor offer, because they wouldn't have had the prior certified copies of conviction for trial. So I can put that on the record. I can also, I think that was one of the major reasons, honestly.
Okay. I mean, I guess it should raise a flag for everybody that Mr. Kalen reported he last used marijuana on or about March 16 of 2026 and cocaine. I took this plea on March 16 of 2026, so I'm surprised nobody seems to be concerned about that. Was he under the influence when he took this plea? Did he do drugs after the plea?
So as far as I can say, in talking to Mr. Kalen about the alcohol evaluation statements regarding his statements about alcohol use, cocaine use, and marijuana use,
Thank you, Beth.
he
Thank you.
indicated to me that he wanted me to correct those statements on the record because he took issue with them and said that he hadn't, essentially they weren't.
All right, looks like I'm getting a spinny thing. It's not RAM. It's something different. Okay, I think we're back now. That was not my RAM. That was network connection, probably because of the storms here. I think we're okay now, though. Right? Are we okay? It looks like we're okay. It's fine. Look, we have 9 minutes and 14 seconds left. We got this. And in case you didn't hear me because of that hiccup, Beth, thank you so much for the sunshine. Thank you. Let me just back it up a few seconds.
alcohol use, cocaine use, and marijuana use, he indicated to me that he wanted me to correct those statements on the record because he took issue with them and said that he hadn't, essentially they weren't exactly what he said.
What did he say?
I think, I guess I don't really want to make statements, but he denied what the statements are in the alcohol evaluation as far as accurately reflecting what he conveyed to probation. He indicated to me that he had made statements about drinking to probation in the alcohol evaluation, but I don't have specific notes about the other two.
Okay. I guess, do the people want me to go forward with this sentencing? And if so, why? I guess I don't want to hear it. I defer to the court. I want to know if the people are saying, please take this plea and sentence accordingly because, or, you know, now we've reviewed the evaluation and we agree, or what?
That's how Judge Manning is. Remember when Judge Manning is like, we're in this boat together, but I'm the only one that's going down. I need you guys to tell me what you want. So she's like, don't defer to the court. The judge basically just told the prosecutor what to say. He could have been high as he was taking the plea, Judge, so we think that you should reject the plea.
What's the position of the people?
Yes, Your Honor. At this time, we would be asking to reject the plea due to the fact that it's unclear at this time if he was under the influence when he accepted the plea. Typically, if someone comes in and they are under the influence, don't make it a practice to, I would object if they are trying to accept a plea while under the influence. Since it's unclear if he was under the influence when he accepted the plea, it's not clear that it was a voluntary acceptance of it at that time. So we would be asking to reject it.
And what are the people asking? I mean, the defense, sorry.
We would, well, I guess, first, I would just note in terms of whether he took the plea under the influence. In speaking to Mr. Kalin, he took issue with the statements in the alcohol evaluation accurately reflecting what he had conveyed to them. I don't have a specific basis to believe that he was under the influence when he took that plea agreement. And then in terms of accepting the plea, I realized this now too, but I think one of the other considerations in extending this was the main officer, or really only officer, main officer, I would say main officer. In this case is LeBaron, who is an officer that is notoriously, his credibility has been at issue in Colorado Springs or generally recently. So I guess I would just bring that up, but I would be asking that the court accept it. Mr. Kalin will have to do both 60 days, well, I think 58 days in jail as part of this plea, but also will have to do extensive alcohol evaluation and treatment. And I think that given the fact that he entered this plea because the people weren't ready for trial as opposed to continuing, if the court were to reject it, would somewhat take away the benefit of the plea, given that the people weren't prepared for trial.
Okay. All right. Regrettably, I'm not accepting this. Like I said, I've done this once. I normally have no problem because I know you guys know more about your case than I do, but I'm just not comfortable. This is, according to this report, Mr. Kalin's sixth alcohol/drug-related driving offense. The court notes that after the plea, he's continued to use, and I understand he may disagree about the day, but he's not denying that he has continued to use marijuana, cocaine, and alcohol. This report was done March 23rd of 2026. He's continuing to use substances. His version of the present offense, he expressed an understanding that through his choices and behavior, he placed himself, others in the community in grave danger. However, he feels that the consequences he is facing are overboard. I think this is reflective of a person who is not taking this seriously. And I'm just not comfortable accepting the plea. So what would we like to do at this point?
You okay? Just catch your breath. You can sit down. You don't have to stand up. If I could have a moment to talk to Mr. Callan.
You can. Yes.
Okay, sorry.
Okay.
I can recall his case.
Okay, we're back on Mr. Kalen's case. What would we like to do?
I would ask to re-enter not guilty, please.
Okay.
If possible, I would ask that, I mean, I don't know if this is possible, but given that the reason we withdrew not guilty pleas was for the benefit of the plea agreement, I would ask that Speedy have been told since we last withdrew them. And so that Speedy trial continue to run. If the court's not willing to do that, then we would just ask to enter not guilty pleas today and Speedy to be 6 months from today, but.
Okay, I was wondering the same thing because I'm not sure what the law is on that. Right now, when the plea was taken, we were 112 days in. So, I don't know what the people's thoughts are on that. Does Speedy, if we're resetting, do we have to stay within the original time left on Speedy? I don't know.
Your Honor, we're unsure. We would need a chance to look at the law on that.
Okay, why don't we set it within Speedy, within the remaining Speedy time, which is 68 days. And then you can brief it, and if it turns out that it's longer, we can keep the day or move it if we need to. But I can do June 9th.
Would it be possible to do the week after that? Is that still within the time frame?
I do not have that week available.
Could we do 2 weeks after that? I'm going to be out this 4th, 5th, 6th, 7th, 8th, or 4th up until the 8th.
Okay, let me see. That may not be within the window, but let me look.
I will also be out on the 9th.
Yeah, we can do that. June 23rd.
Okay.
At 8:30.
23rd at 8:30.
Okay, June 23rd at 8:30. And then pre-trial will be June 16th at 10. All right, June 20. What did we say? June 23rd at 8:30, June 16th at 10 for pre-trial.
And does the court want a motion regarding tolling of Speedy, if that's like what I'm gonna stand on?
Yeah, I think just your authority, like summarized, with a case site. I don't need like a formal recounting the history of the case or anything.
Okay.
Yeah. And if both sides could file that, your authority, will say within, I'd say by next Wednesday, the 20th.
Yes, Your Honor.
Anything else? No?
No, Your Honor.
Okay, we'll see.
I wonder why in this courtroom they have the bottom half of the one camera blurred out. I don't understand. Thanks for coming. Have a good lunch meeting. All right, guys, we made it to the end. Thank you so much for coming out today. I appreciate it. I do. I'll see a lot of you in a couple hours. Get some beauty sleep and I'll see you soon. All right? Have a great night, guys. Bye. Thank you.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide.